seated, please. Welcome, everyone, and thanks again to the Court of Criminal Appeals for lending us the use of the hall. Two cases on the docket this afternoon. The first is Appraisal Review Board of the Harris County Appraisal District versus Texas Workforce Commission. Who's present for the appellant? And appellee?
William Cohen for the appellee, Texas Workforce Commission.
You got time for rebuttal? All right, you may proceed.
May it please the court. This case raises an important issue for the state, for all of the large appraisal districts throughout the state who have a lot of work to do in a relatively short period of time every year, but then for about 6 to 8 months of the year, there's very little to do. And the legislature sets this up because the tax rolls have to be approved by a certain time. All the tax protests have to occur within a certain time. And so the folks who serve on the appraisal review boards of our district, as well as those in these large counties, have to in effect overhire for the peak tax protest period. And then during the off tax season, there are a lot of people with very little to do. Our legislature has set it up to where they are paid on a per diem basis. So unfortunately, unlike with school teachers, we can't structure their compensation to even out over the course of the year. They're paid per meeting that the board is convened, and then that's it. So we're sort of in a jam with this, and I think a few of these folks know enough about the law to be dangerous, and so what they've done is they figured out that they can go over and apply for unemployment compensation and get the appraisal district to, in effect, supplement their income with unemployment compensation during the lean months. Our position is that the statute doesn't require that what we view to be unjust result, and also a result that is not in consonant with the purpose of the unemployment compensation statutes.
Which statute says you can't do that?
I'm sorry, Your Honor?
Which statute says you can't do that?
Okay. Let me start with Section 201.091E, which the Supreme Court in the Wichita County case referred to as an exception.
Labor code, correct?
I'm sorry?
Of the labor code, correct?
That's correct, Your Honor.
I mean, you guys deal with this every day. I do not.
Okay, yes.
So let's be specific, if you will.
It is of the labor code. Yes, Your Honor. All right. It says, for purposes of this subtitle, an individual is not considered unemployed and is not eligible to receive benefits for any benefit period during which the individual works the individual's customary full-time hours, regardless of the amount of wages the individual earns during the benefit period. Okay. This statute then, what it's doing is it's saying that if you look at a benefit period, and benefit period is a defined term under 201.011.4, 7 consecutive days. So we're not looking at, what do they make, how many hours are they working during the peak period, and then we compare that to, well, they've dropped off to only one meeting a week, and so shouldn't we analyze it in terms of 40 down to 8? But that's not how the statute's written. It's written in terms of a benefit period, and it's written in terms of customary full-time hours. So what are customary full-time hours? We think in terms of the labor code, or the Fair Labor Standards Act is requiring up to 40 hours a week as full-time work. But customary full-time work for this employer is what the legislature has dictated is the workload for this particular governmental entity, and that is they have a peak period when they are going full blast. 40 hours a week is common. But then when the off-season hits, there may be 5% of the caseload is what's left, and then it trickles down to even less than that. So they may get one hearing a
Is full-time
week.
defined anywhere?
I'm sorry?
Is full-time defined?
It is not.
It's not,
And I
right?
looked, and I don't see that it is defined. So full-time.
I guess my concern, and maybe it's that customary is doing the work here, is that usually if there's not a statutory definition, we have to go to dictionaries. And I think full-time, most people would commonly think of that as 40 hours. And so is it the word customary that's doing the work that's changing maybe the ordinary meaning of full-time?
Well, but the statute
Right.
says the individual's customary full-time hours. It doesn't say, what most people.
But she would be doing full-time at a different time of year. She would be doing 40 hours at a different time of year, just not this time of year, right?
And we're talking about a pay period.
Right.
We're talking about, a seven-day pay period within the meaning of the word pay period. And our pay periods drastically differ depending on what time of the tax season you're talking about. So my view of it is that this untoward result that the Employment Commission has decided in this case is appropriate is very easily fits within this exception in the statute.
So the argument would be, for appraisal review board member, your customary full-time hours in the off-season is 8. Well, I guess it's per week, so tops 8.
Yeah, they may get one meeting a week.
Yeah, and so, if they're getting 8 hours, that's customary for that line of work.
That's right. That is their full-time, that is full-time for that particular point in time.
Of course, all the rest of the statute, 201, base period is you're looking at huge amounts of time, base for the last 5 quarterly periods, and then it's either bigger or much smaller because it's benefits per week, and that's the benefit amount is figured. But so it's just, in your view, the question is whether customary is requires, and I guess TWC decides that in the first instance, and then with the appeals process and all that.
I think that the term customary is not defined in the statute either. Dictionary meaning of customary. You look at what's usual per the circumstance, the specific circumstance. And the specific circumstance here is dictated by a very intensely regulated tax protest process, where all this has to, this isn't like I think that we had the restaurant analogy where or a clothing store.
Christmas tree sales, 100 things I can think of that are up and down and on and off. And according to the briefing, this has never, except for the Redona case, this has never been decided what that means in season with regard to never been applied in seasonal work.
Yeah, this one is a sui generis matter. It's an unusual. This is an unusual employment situation because taxes have to be the tax rolls have to be certified at a certain point in time, and all the protests have to occur within a certain time. And it's not like your common private businesses that can structure their compensation packages to allow for the pay to be equalized.
And I assume this is not just a Harris County problem. Like, I assume this is a issue for any ARB member of any county in the state. I mean, or is it different in Harris County?
Yeah, the counties have different number of taxpayers and average different number of protests. We used one of the, I think it was Loving County or one of them that they may have 6 protests a year. Dallas County or Bexar County or Harris County, they have 500,000 people file protests, and then over 100,000 end up in these formal ARB proceedings.
Friend of a friend says he considers it a blood sport in Harris County. Every year you contest your appraisal, and every year you get a little bit knocked off. But we can't say, I guess you can't tell ARB members when they sign on, look, and you can't apply for unemployment compensation.
I don't believe that would be appropriate at all. I mean, they can certainly apply, and there would be situations.
Statutory right, I don't know if you could waive that one or not.
Yeah.
It's,
That there would be situations where the law would apply. For example, if you terminate somebody without cause, and there are procedures to remove these folks, and so if they want to contest that, hey, I didn't have my hand in the cookie till, or I wasn't, there was no conflict of interest, or whatever they get fired for, they could contest that and then presumably receive the benefits. But our point is that when the reduction in hours comes about as a result of the statutorily dictated reduction in the workload for these huge ARB boards in the big cities, particularly when we do have to overhire to cover all the work, that the unemployment compensation system should not be used to come in and say, well, yeah, the statute says I get per diem pay, and they've told me from the get-go that that's all I get, but if you reduce the hours by a certain amount.
we're forced to do this by statute. That's an exception to the chargeback issue, not an exception to whether you get unemployment compensation.
It's harder to get an act of Congress, so to speak, than a reasonable opinion from a court that I think can construe this language to yield that result on this special set of facts. This is, our case is going to be a very unusual case, but it will affect a lot of boards around the state.
Well, I guess my question is, if we were to give full-time, just very hypothetically, this, customary aside, if we were to give full-time, it's kind of more common meaning, looking more, at 40 hours a week or something. I mean, there's no rule that says a plaintiff can't take advantage of a badly written statute. I mean, there's room for the legislature to fix it if they think it's really wrong. I guess my question is, can we truly be faithful to the text here and come to what seems to, maybe a more logical result? But it certainly seems like the legislature could have fixed it with some better language if they'd wanted to.
They could have. The trial court in our case made a few findings that, or not the trial court, it was the appeal tribunal. Made a few findings for which there is no substantial evidence. For example, that they are hired on a 2-year term with an average hours of 40 hours a week. I mean, the evidence that was before the trial court and before the ARB, there's no evidence to support that they get 40 hours a week. I mean, that's just not the case. And I don't know what you'll hear from opposing counsel, but there's no evidence on the record to that effect. And then that the employer reduced her hours. And again,
This is, I mean, basically par for the course. She's doing the same thing that everybody else is doing, right? Yeah.
They convene three judge panels to hear these tax protests, and it depends on how many tax protests. If y'all had no appeals, you wouldn't have any work, but you'd still get your salaries. But here, if there were no cases to hear,
Would that were true.
if there are no cases to hear, that the job duties don't involve, well, you can go clean up or something. There's nothing for them to do under those circumstances, and so we're not reducing their hours like the employers do. In the short amount of time I have left, I do want to cover the other issue, which I think is even a clearer statutory provision that at least the ARB, the taxpayers of Harris County, don't get left with the bill to pay the unemployment compensation. That it would apparently, I guess it would be statewide. The legislature makes the mistake. You would think that would be just, but the provision on the chargeback that if the statute requires that the reduction in work occur, which we've shown that it has very clearly, I mean, it's not like that we have any discretion over this, then we shouldn't be saddled with the chargeback. And that's my second point. I would rather the court use the exception that's available in the statute and construe it to catch this type of narrow situation than to say that, well, you don't get charged back, but still it's unjust to put this additional expense on the taxpayers of Harris County when if the state has passed a law that doesn't accomplish what it's intended to accomplish, the taxpayers of Harris County shouldn't be made to pay it. I mean, the Loving County,
Who will pay it?
I assume that it would come out of I'm not sure which fund of the state government would pay it, but that the chargeback wouldn't
So
come from us.
unemployment not funded by employer contributions?
Yes, I assume that's right.
All right,
I see my time is about up.
thank you. Mr. Cohen?
May it please the court. At the end of the day, this is actually a pretty straightforward appeal of a TWC unemployment benefits decision that's governed under the substantial evidence de novo standard. The labor code defines unemployment in this state to include partial unemployment if an individual has his or her wages fall beneath a certain threshold. In this case, the TWC had a reasonable basis to conclude that Ms. Redona Hall, who's the co-appellee, couldn't be here today, she's a teacher, couldn't make it up, that her hours fell beneath that threshold, and there weren't any other exceptions that would have disqualified her from benefits. The commission applied the plain language of the statute to the undisputed facts in this case, and substantial evidence supported that decision. That means the law requires affirmance.
What is the commission's definition, to the extent it has one, of customary full-time hours for her?
That's a great question. And I think when you look at that phrase, you have to look at all four words. It's customary full-time hours. Now, the phrase in itself isn't defined in the code. Mr. Viata was correct about that. However, there are other sections of the labor code that define a full-time work week as 40 hours. Black's Law defines full-time as usually 35 to 40 hours. So I think when you're looking at an individual's customary full-time hours, it is, yes, that individual, it is customary, but it's full-time. It's what would commonly be defined as full-time work. So something in that arena of 35 to 40 hours, Justice.
But is it, by using the term customary, is legislature signaling that we look what's customary to that individual employee?
It is customary to that individual employee, but I think that's modified by full-time. It's not just customary hours, it's customary full-time hours. And I think Justice Ferris pointed that out, that full-time does have a specific meaning. Even if that entire phrase isn't defined in the code, you have to look at all four words. And in this case, the commission saw that she was working an average of about 40, that dropped to about 8. So that's about an 80% reduction. So I think there is a reasonable basis here for the TWC, who has the authority to make that kind of determination, that she wasn't working her customary full-time hours anymore.
Is it a defined term, full-time? I'm not finding it.
The customary full-time hours is not defined. There is a different section of the code, it's Labor Code 408042, which defines a 40-hour work week as a full-time work week. And that's for a different area. It's for computing a individual's average weekly wage, but that's just one section of the code that does talk about what a full-time work week is.
Thank you.
So the standard review in these cases is substantial evidence de novo. Justices might be familiar with that, but at the end of the day, it means that the appellant has a pretty high burden. They have to show that there is zero reasonable basis for the decision, or that it was somehow arbitrary or capricious. As long as there's substantial evidence, which is anything more than a scintilla, the law requires that the decision be affirmed. In these cases, the TWC is the fact finder. They have the authority to attach whatever weight to whatever pieces of evidence are presented to it, and they can make credibility determinations.
So we are modified here in that it's substantial evidence, but it's actually based on what happened in the trial court. Is that not correct?
So when a court is looking in these types of cases, they're looking to see if there's a reasonable basis for the underlying TWC decision. So the trial court's really only conducting a review if there's a reasonable basis. So in this case, you are looking at what the trial court did, but as long as the trial court found a reasonable basis, that is, a average person could could reasonably agree with the decision, the court does have to affirm it. So it's a little bit of both, Justice.
Okay, so just make sure I understand, because I did think it was a little confusing in the briefing that this is a modified substantial evidence review. I took it to mean that the trial court could actually hear additional evidence if he or she chose to.
It is de novo. So yes, you could hear additional evidence that maybe say wasn't available or known at the time of the initial TWC hearing. But again, the court's just looking to see, hey, was there a reasonable basis for that decision? Hey, even if I might not agree with all of it, as long as there's some reasonable basis, I have to affirm it. So it is a pretty high standard to get those types of decisions reversed by the appellant in this case, or anyone trying to reverse a TWC decision. So
Is it a reasonable interpretation of the statute, in your client's view, that you compare what a per diem employee works at a certain time of year compared to the prior years? In other words, it'd be their customary full-time. Could full-time not mean 40 hours a week? It actually mean customary full-time for that employee?
So yes, I do agree. It could mean customary full-time for that employee. You are looking at the individual employee. However, I do think full-time does have a specific meaning in the labor code and a common definition. So I think you can't just look at customary hours. Again, you have to look at customary full-time. So I think in this case, the TWC did find, hey, she was working an average of 40 hours a week. That's customary full-time. That dropped to 8. That's the sort of determination that TWC can make, because it hears evidence from both parties. It heard testimony from Ms. Hall and the board. It saw evidence. It saw schedules, handbooks, calendars. So that's the kind of decision it can make, looking at the evidence that was presented to it by both the ARB and Ms. Hall. And it decided that, in fact, no, Ms. Hall, she wasn't working her customary full-time hours when she dropped to that slow season.
Yeah, I mean, some of what appellate courts grapple with is the ripple effects of what they decide. How, with TWC's argument it's making and the trial court's findings, how is every seasonal employee not entitled to unemployment during the off-season?
So I think the answer to that is if they meet the threshold, they are. I think any employee in Texas, if they're working a job that has a seasonal basis where there's going to be a slow period.
The threshold, what do you mean?
So that's a great point. So Labor Code Section 201091 has sort of a formula for when a person becomes partially unemployed. And it's a pretty technical definition. I can read it off. It's essentially if that individual's wages payable for that benefit period are less than the sum of the benefit amount the individual would be entitled to receive if they were totally unemployed, plus the greater of $5 or 25% of the benefit amount. So it's a kind of technical math definition. But I point out here that I don't think the appellant or anyone's sort of challenged the decision on the basis that, hey, Ms. Hall technically wasn't meeting that definition, that she was partially unemployed on the basis of
No, I agree,
hours.
but I can't imagine why it wouldn't apply to Christmas tree lights and firework retailers.
I think it absolutely would, Chief Justice, if they're meeting that threshold and they're not falling under any of the exceptions, like they were fired for cause or they voluntarily quit, something like that.
Are there opinions that I guess involve, not necessarily like a Christmas tree salesman, but something kind of more on, I mean, this is a very unique job, but is there a type of opinion that, like, say it comes up all the time with this particular type of employee that would be maybe somewhat analogous that we could look at here?
So it is sort of a unique situation. I'm not aware of any decision that specifically points to, hey, they're part-time, so we're going to analyze it in that benefit. I can point you to the Wichita County case,
Right.
which I think Mr. Villada mentioned, which says, and I'll quote it directly, an individual qualifies as unemployed if his or her wages are low enough. So that's what you're looking at. You're looking at the amount of wages they're making in a specific period. That's the real, threshold here as to whether Ms. Hall or anyone is qualifying for unemployment benefits, partial or not.
So, but it's never come up before.
I don't know on the top of my head, Chief Justice. It's been specifically in the context of partial unemployment.
Who would know better than you?
Good point. I can tell you that when you're looking to determine if someone's partially or totally unemployed, you're looking at the statutory definitions, and there's no case law on point that says you don't get partial unemployment benefits. No, you can be partially unemployed in the state, and you can get partial unemployment benefits if you're meeting the plain language of the statute, if you're
And
following
is
in
it
that
right that
category.
there's two trial courts that have come out different ways, and there are also abated cases that are pending on this?
For this case specifically?
Well, on this issue.
Yeah, so there are multiple, this TWC and ARB does have multiple cases that are abated right now
Yeah.
that are pending the resolution in this one. In terms of, like, I think Mr. Vigas said, this specific instance with an ARB, it is a sort of issue of first impression. There hasn't been anything that's decided on this specific
Interpretation.
employer. Yeah. I will say, however, to that point, in 2017, there was the Harris County versus TWC case, which establishes generally that, hey, ARB members are employees and they are eligible for
Right,
benefits.
right, and so that may explain why none of this came up before, at least with regard to ARBs, because everybody thought they weren't, but, I mean, I get your point, the statutes mean what they mean, but, we do need to consider the consequences, and if I like Christmas tree lots, but everybody else may not, but, if every Christmas tree lot has to pay their workers not just the $10 or $15 an hour plus tips that they make, but also unemployment for weeks and months thereafter, and basically hold them over. And I think ARB is a little different. They want to keep these people around because they're highly trained, and so why shouldn't they be like teachers where you pay them so they don't go do something else? And maybe Christmas tree lots not a concern, but there's a lot of people out there doing lawn services and Christmas tree lots and all this stuff, and if all of a sudden we basically raise the cost of employment to double it because of permanent unemployment compensation, we're going to hear about it.
Absolutely.
And you will too.
My docket will be full, but I think what might be a little different in, say, that example where someone works a Christmas tree lot. Usually those sort of Christmas tree lots, they're closing by January. So it's not a scenario where you're going to have a worker who's still working March, April, May, and applying for partial unemployment benefits.
Yeah, but you pick the highest of any of the previous 5 quarters, and that's going to be the one that includes Christmas.
Sure, and absolutely, and I guess my response to that is a little bit, hey, the labor code allows this. The labor code allows for partial unemployment benefits. The legislature set it up that way, and the TWC, hey, we're tasked with, protecting employees in the state, and sometimes that means they are going to get partial unemployment benefits, and that's just sort of the way it's written. I think if you look at that 2017 case, similar arguments were sort of made there, and the TWC's attitude in that case was, well, again, the labor code, there's nothing special in either the labor code or the tax code that says ARB members aren't employees. I think that's the same here. There's nothing special in the tax code or the labor code that doesn't allow for employees like Ms. Hall to get benefits in this specific scenario. I'm certainly sympathetic to the ARB, and it might be a situation, like you said, Justice, where, hey, next legislative session, they need to go through and amend or clarify some of this language, but as it stands today, here, Ms. Hall getting benefits is allowed under the labor code, and any other ARB employee member who files for benefits and doesn't fall under one of those exceptions, it's allowed. They can get benefits. That's perfectly okay.
They have a second argument, which is that even if you find this is an underemployment situation, the statute is forcing us into this. And I know the main counter is Retama, which I think is distinguishable. So what in the statute makes their argument incorrect?
So I think you're referring to the chargeback argument with the Retama case. So I think the key phrase there, in which Mr. Viata pointed out, that's required by statute. And I'll give you an example of when I think the chargeback protection would kick in and the ARB wouldn't get charged. So if Ms. Hall had served the entirety of her term, like she did here, but she waited until after her term was over to apply for benefits, and she got benefits, that's a scenario in which the ARB would be protected, because in that situation, her separation from employment, her term ending, was directly required by statute, because the statute says, hey, your term's 2 years, it ends, so even if she gets benefits in that scenario, she can't go, or the ARB can say, hey, look, the statute requires that her term's over. That's required by statute. So I think that's sort of the key example of when the protection would kick in. Here, what we have is a reduction in hours. We have a partial separation from employment because her hours were reduced. And Ms. Hall would admit the state's admitted that, yeah, that's because there's a seasonal nature, it's busy and then less busy, but that's not a specific scenario in which the separation is required by statute. Now, there absolutely is a calendar of deadlines the tax code lays out that Mr. Viad pointed out. We don't dispute that. But those are any employment decisions that get made as to individual ARB members, that's all going to be downstream of those calendars and deadlines that are laid out in the code. There's nothing that says, individual ARB members have to get a minimum number of hours or a maximum number of hours, a minimum or maximum number of assignments. So in this specific scenario, and it's a little weird, but in this specific scenario, the chargeback protection does not kick in because, again, nothing about the reduction in her hours was required by statute, or it wasn't directly required by statute if you're looking at the Redona case.
I guess the key, the word to interpret there is required, because, the statute is setting them up, so to speak, for failure, right? You're required to hire enough people to get you through the busy season. They're required to give them 2-year terms, and they're required to give them per diem pay, which necessarily means that in the down season, they're going to have too many employees, not enough hours, and there's going to be unemployment benefits. So how is that not a requirement?
So I think what's required by the statute are the deadlines they have to meet, that they have to get a certain amount of work done by a certain period. And there's certain time periods in which, people who own homes in Harris County can get a timely, hearing of their challenge. That's what's required. Any employment decisions that they're making in terms of the individual ARB members, again, I think that's all downstream. Or to quote Redona, that would be an indirect consequence of those statutory provisions. Because in Redona, I'm sure you've read, that was a security guard who got laid off because the horse racing track closed early, and they got permission from the Texas Racing Commission to do so. In Redona, they said, okay, well, yes, you were required by statute, to get permission to close, but that doesn't affect the actual employment decision you made as to the security guard. I think similar logic applies here. You have someone like Ms. Hall. Yes, unfortunately, there's a schedule where she's going to be working less later in the year, but again, the only thing that's required by statute are those deadlines, or in a scenario where she finished her term and then applied for benefits. Well, in that case, the separation from employment is required by statute. I think that's the key term, is it's separation of employment that's required by statute. That's the two things I think you have to look at for that chargeback issue. So unfortunately, I do think this is, admittedly a little bit of a weird scenario, but as the statute has written, it doesn't protect the ARB from chargeback in this specific circumstance. So to affirm here, the court really needs to only answer one question, which is, could reasonable minds have reached the same conclusion as the commission? And I think in this case, the answer is yes.
Not really on statutory construction.
Well, correct, absolutely, Chief Justice Christopher, and I think you're looking at the reduction in her hours. I think that is something that reasonable minds could conclude. And I also do think there's a reasonable basis for the TWC's interpretation of the statute here too, that Ms. Hall both qualifies for benefits and that the ARB is unfortunately not protected from chargeback. So I do think there's a reasonable basis on both the facts and the law here.
Here, what do we make of this section, I guess 207045, the voluntary departure, or
The
here
voluntary
kind of,
quit exception.
Yes, and it does say left the individual's last work voluntarily, so maybe it is really talking about quitting, but to me it seems like, and this is just, I guess, a guess, but I would assume people seek out a job like this maybe for a particular reason. Maybe, they've got a house somewhere else in another state that's a lot prettier at certain times of year or something, and maybe they want to, or maybe they've got, some other type of, university teaching,
Sure.
something like this. I mean, this seems like it would appeal to a particular kind of person who maybe doesn't want a 40-hour schedule
Absolutely.
all year long. So why wouldn't this kind of kick in and take care of everything?
So I think the voluntary quit, that's really good. I'm glad you brought that up. So voluntary quit, the logic there is, okay, if you're working a job and you quit for your own reason, then yeah, you're not going to get unemployment benefits in most cases, because you quit voluntarily. I think here the key factor is Ms. Hall served the entirety of her term. She served the entirety of her term, of her 2-year term from beginning to end. She didn't submit her resignation until the very end of her term, that became effective on the last day of her term.
But I guess she voluntarily took the hours drop. I mean, she knew at least what she was getting into.
Sure, absolutely. And I think she testified to that too, that
Yeah,
yes, I knew coming in that there's gonna be a busy season and a slow season. But I think, there's no foreseeability exception anywhere in the labor code. The fact that coming into a job like this that yes, my hours might go down later, there's no exception that says you don't get partial unemployment benefits in that case. And I think the voluntary quit exception is really looking just, hey, did you quit your job voluntarily or not? And the answer here is no, she served the entirety of her term. So I think by the plain language of that statute and the plain facts of the case, she didn't voluntarily quit. She served the entire amount of her term, even, yes, some portions of that term were gonna be at a lower hour rate than other parts. So in this case, the commission applied the correct law. It relied on substantial evidence, and the trial court correctly affirmed. It did not, and it should not have, reweighed the evidence. It came to the correct result, finding a reasonable basis for the decision. The ARB today asked the court to rewrite statutes, create exceptions, and override agency fact-finding. The law does not permit that. The commission applied the statute as written, the plain language of that statute, and reached a reasonable conclusion. Under substantial evidence review, the decision must be affirmed.
Do you have seasonal employment at TWC?
I'm working at the AG. We're the reps for the TWC, and thankfully,
Does your client have seasonal employment?
That's going to depend on the job, obviously, but no, most don't. Most are salaried employees. So,
Not your problem, not their problem.
the TWC is always looking out for employees in the state, and even someone like Ms. Hall, I think she deserves her benefits here. So we ask the court to affirm the judgment of the TWC and the trial court.
Thank you, Mr. Cohen.
All right, in my short period of time, I want to come back first to the chargeback provision and then try to tick off some of these other arguments. First of all, I wanted to clear up what I hear to be a distinction between termination type decisions and reduction in work type situations. And I think from his perspective, the requirement phrase would only apply if they are required to give up their jobs because they're term limited out, but it wouldn't apply to reduction in work where the statute says you must have all the hearings within a certain period of time and then there are no more hearings. And the statute doesn't give the ARB the authority to have people clean up and do odd jobs during the off season. So it is required. It's absolutely required that the work is very heavily weighted towards the protest season and that it necessarily falls off drastically, and especially in these large counties where they have to overhire. That's one point. I heard that he referred to this as employment decisions. Again, this is not an employment decision. The employer here has no control over how many hearings are held, just as this court has no control over how many people decide to appeal their cases. The discretionary aspect of this, like in the case that they were citing, this is involved a business decision to cut back because there wasn't that business. One of the findings of fact that were made in the agency was that it was because of a falling off of business that the employer here cut back her hours. That doesn't fit this set of facts. All right, the customary full-time, not statutory full-time, the individual's customary full-time hours. And it is not eligible to receive any benefits for any benefit period. That is a week. Each benefit period is a week during which the individual works the individual's customary hours. So what they want to do is say that, well, it's all 40 hours a week, and so when her customary work week during the off season drops down to once a week, that's her full-time her full-time schedule. And it was customarily her full-time schedule, and we have evidence in the record to show that. There is no evidence to support the appeal tribunal's finding that she, on the average, worked 40 hours a week, and that the employer dropped her hours as a business decision. That doesn't fit this set of facts. They
So
were
full-
applying,
sorry.
they were applying your standard old private employer paradigm to a unique statutory setup where.
Well, I suppose there's a business decision, you could decide to hire them all for the business season, let all but 20 or 30 go for the rest for the off-season, hire people back the next business season. So why isn't that a business decision? Not to do that because you want to keep them all on board. So you
Well,
don't have
because
to hire a bunch of new people.
they are hired for a certain term, Your Honor. I mean, we don't, if they're not terminable
No
at will.
discretion.
And we can't hire them just for Christmas season and then, y'all go back to school in the off-season. They are officials for that 2-year period. And then they're eligible to renew twice or three. They can have 3 separate terms, so 6 years total. But once they're there for 2 years, and we can't fire them at will only for cause. All right, so that again, we don't have discretion. Then finally, the voluntary voluntary exception, where the employee voluntarily leaves work. Let's see. Yeah, voluntarily leaves work. Okay, so she accepts when she takes this job, and the statutory scheme is all explained to her. That you have a peak season and you have an off season, and she knows it, and she admitted it on the record in every proceeding she was in. That's the term of her employment. And so when she voluntarily accepts a job that necessarily by law drops off when the tax protests are all completed, she has also voluntarily accepted that reduced work schedule. And so we would argue too that is yet another way in which this court can write an opinion that makes sense from the standpoint of these types of entities having to deal with these particular labor problems. I see my time is up. Thank you for
Any
your
further
patience.
questions? Thank you very much, Mr. Beata. The case will be submitted. We'll take a brief break. Thank you. Be seated. Last case on the docket today is Hayes County, Texas et al. Versus Leslie Carnes et al. Who's present for appellate? Reserves time for rebuttal. Reserve time for rebuttal.
Yes, 5 minutes.
Thank you. And for appellee?
Bill Evershire for the
Good to see you. Thank you, gentlemen. You may proceed.
Thank you, Your Honors. This case poses essentially two questions. First, was the notice that was posted for the meeting at which an election order was issued sufficient under the Texas Open Meetings Act? And that's an important question because the Open Meetings Act obviously is an important statute, and particularly important because, as the Association of School Boards amicus brief pointed out, it can affect bond issues all across the country because they use this sort of notice. The other question, though, is did the district court have jurisdiction to consider the open meetings violation as part of an election contest, and did that court have the authority to invalidate the election on that basis? And the answer to that is no. And
Is that-
that's- I'm sorry.
Is there a case that says so?
Well, there is
From
certainly,
other than from 1924?
well, there is certainly a statute that says that the only way you can enforce the Open Meetings Act is through injunction or mandamus. That's 2019 Texas Supreme Court, Town of Shady Shores. And that case was not an election contest, it was a declaratory judgment action, but the court said you can't bring a declaratory judgment action, you're limited to these two. And because of that, that does not include an election contest. The other thing, and I think if we go to the Scarborough versus Eubank, and that's an older case, 1899, and it obviously predated the Open Meetings Act, but in that case, what happened was it was moving a county seat. And to do that, in order to call the election, you had to be presented with a petition with either 100, 200 signatures, or the signatures of the majority of the whole county, depending on how long the existing town had been the county seat. And in this case, the county judge was presented with a petition. He called the election pursuant to the petition, which he has to have to call the election, and the election was held. It passed and it was challenged. And the Supreme Court said the object of popular election is that the will of the greater number of voters may prevail. Hence, the important matter in every election is that the will of the voters should be fairly expressed, correctly decided, and legally enforced. And then they said, compared to this, the question as to the manner and time of ordering the election is of trivial moment. So in other words, once the people have spoken, and the people, of course, in the people reside the basic political power. Once the people have spoken, you don't go back and say, well, we're going to throw away this election and the voice of the people because somebody made an error in counting a petition or doing an order. And that case has been cited at least once by the Supreme Court, 3 times by refused cases, cited and followed, as well as at least a couple of other Court of Appeals cases. So it's an old case, but it's venerable, and it stood the test of time, we believe.
Well established, I've heard it.
I beg your pardon?
Well established, you're saying.
Well established.
What is the remedy, though? If let's just assume there's a TOMA violation, and the TOMA violation is related to an election.
Right.
What's the remedy for someone wanting to seek civil relief for a TOMA violation in that situation?
Well, you bring an injunction or a mandamus, and with an injunction, you can enjoin whatever action the governmental body has taken in violation of the act. Now, I think there are some issues about that with an election that are maybe different than some other governmental actions. But the one thing you do, particularly in an election, is you file your injunction, you do it quickly, and you get in hearing quickly. And people know how to do this. Mr. Elshire, same election that we're talking about here, in a case involving the city of Austin, an order issued one day later than the one in Hayes County, filed an application, filed an injunction, got a hearing, got a decision that there had been a violation of the act, and that election was pulled down. Here in Hayes County, they didn't file this in a day or two after it happened. They filed it more than 2 months after it happened, and after the election voting had already started, early voting and absentee voting. So, you know, if you sit on your rights, you're not going to have an option.
All right, so-
And I'm not saying that it's easy.
No, I
But-
don't take it that way. But are you saying that the election moots the issue, or are you just saying there's not any other available civil relief in the statute? Or is this a mootness issue, or is it something different?
Well, there are options for civil release under the statute through injunction. Now, as far as an election, if you want to bring an election contest, which is what we're talking about here, you have to follow the statute that defines what the scope of authority or scope of inquiry is in an election contest, and that's in the election code, section 221.003, and that follows cases that we cite in our brief that go back to the 1870s and through the years saying.
So you're saying based on the relief sought, anytime you're trying to set aside the result of the election, regardless of the ground you're in?
If you're going to set aside the election
Right.
that has already happened, you need to do that through an election contest.
Okay.
And to do that, you have to follow the statute. And what the statute says is you look at were legal votes uncounted or illegal votes counted, or because of mistake, fraud, or illegal conduct, there's a mistake, and the canvassed result, and the canvassed result is so many votes for this proposition, so many votes for that proposition, and which prevails, is not the true result. So if you look at how many votes or change, and you have to be able to show in an election contest that you change enough votes or you change the count enough that it makes a difference. And there are plenty of cases that say that. In this case, the election, almost 116,000 persons came out and voted, and it prevailed by a margin of more than 13,000 votes. And nobody's suggesting, in fact, the Ampley's brief, I think, says, you know, we're not challenging the vote totals. Well, the people voted.
Sorry, I should have looked to see, did the ballot language explain how much the taxes change were going to be, what the total amount of the bonds was going to be, what the projects were?
Yes, and if you go to the, not only in the ballot proposition, but with a bond election, there are all sorts of newspaper notices, posted notices, et cetera, all of which were done, and there's no contest about that. Everybody going in to vote knew what was going on. Let me switch over to the issue of the notice. And
I mean, it could have been more particularized here, right?
of course it could.
Right.
You can always make it more particular. And you run into the problem that Chief Justice Phillips talked about in the City of San Antonio case. If you make it too particular, you overwhelm the reader. You know, and I could certainly argue roads, the question was, should we have said roads, should we have listed
Yeah, but I
the
mean, it's in a
30?
miscellaneous provision, right? I mean, is that really gonna draw anybody's attention, given the scale of the project that it?
Well, you know, if we had put it under roads, for example, I think that somebody would come in and say, wait a second, that's a bond election, that's talking about money that's gonna come out of my pocket. I don't wanna look at it under roads. You know, if I'm looking, I need to see it somewhere else. And the notice that we're talking about here, I don't know how many items there were, the great majority of them were on the consent agenda, and so there weren't that many that were there. But here too, you have, as you're required to have, or were required to have at that time, two notices.
Right.
A posted notice at the courthouse, which was paper, and a notice on the county website. And if you go to the county website, you get to that agenda item,
And there's a link, right?
and you have one click, and actually takes you to the cover page of that particular item. You click again, and it takes you to the proposed order, which lists the different roads. It lists the amount of the bonds and all sorts of other things.
And do we know how many clicked on that? Do we know how
I
many
don't know
people?
how many
okay.
looked at that,
Yeah.
but I assure you that, well, common sense would suggest that many, many more people get noticed by going to their computers than walking past a bulletin board in the courtroom.
Well-
I don't think very many people walk every 3 days to the courthouse to see what's been posted.
This raises another question for me. Yeah, the case law in this area is mostly old,
Yeah.
and a lot of it's pre-internet. So is there anything in the statute that requires the posted notice in the courthouse that it's looked at in a vacuum, or can you look at it now combined with the electronic notice?
Yes, and if you go to, well, this is not exactly that answer, but pretty close. If you go to the City of San Antonio case, Chief Justice Phillips' opinion there, and in that case, they posted it was in City Hall, posted in City Hall, but City Hall was closed at night. It has to be posted at a place readily accessible at all times. So they also posted at a kiosk outside the City Hall. And Chief Justice Phillips said, to see if it was posted in the City Hall or at a place readily accessible, you can look at both and you can put them together. And I think that's the case now. So,
I was trying to find in that case if we had any inkling of.
I beg your pardon?
I was trying to find in that case if we had any inkling if the one on the kiosk was the same as the one in the courthouse. That would have been
Well,
nice to know.
In notice, one of the things I think about the adequacy of notice, an important case, is the Turnpike Authority case. And it's one where Dallas-Fort Worth Turnpike was going to be a free road at the time the bonds were paid. People were anxiously looking forward to that. And all of a sudden there was a notice that said, we're going to hear a proposal to consider bonds to enlarge the turnpike. And people or the city of Fort Worth said, wait a second, that's not adequate notice. You're not telling people that this is going to mean that we're going to pay tolls for another 30 years. And the Supreme Court said, you do not have to tell all the consequences that may occur. You know, that notice was sufficient. Now, here, and by the way, the notice here said, we're going to consider issuing an order for a bond election and some other material, like sitting polling places, that sort of thing. And that's exactly what they did. They called the election for the people to decide. And, we didn't approve, or the court didn't approve particular items to build. It sent it to the voters, and later, in various cases coming down the pike, they will decide whether and when to build particular ones. And that will be at the later meetings. But the other opinion is Friends of Canyon Lake. And that's one that is very similar. People had environmental concerns. it was going to involve $75 million of improvements. And they said, wait a second, what's going to happen is, if this passes, you're going to double the amount of water you're taking from Canyon Lake, and you're going to have to spend this $75 million, and you can send that water somewhere out of the service area. And the Third Court of Appeals said the notice was adequate, and it didn't mention any of those things. It just said, consider a water treatment agreement, essentially. The notice was adequate, and it gave an inkling of what was going on, and that was the standard used by the Third Court of Appeals.
Thank you, Mr. Heath.
Thank you.
Mr. Ailes?
May it please the court. The trial court did not err in finding that the wording of the Commissioners Court meeting agenda, the key phrase being order calling a bond election, inadequate under TOMA standards when compared to the election and what the election order actually did, which was to order an election for road bonds for controversial roads in an amount that would be more than double the county's bonded indebtedness level.
But why why don't we have to treat this as an election contest? I mean, now that the election's happened, why don't we have to look and see if the result would have been different?
Well, this was filed as an election contest.
Right.
And
But
by
why
the way,
don't
I
we-
was not
yeah.
trial counsel, but,
Yeah.
but
But why don't we have to consider that and look and see if, given the margin
well,
of the election, why don't we have to look at that?
because the legality of the election is an issue, not just whether it passed. If everybody in Hays County had voted and supported it, I mean, I understand from a practical standpoint how the Open Meetings Act applies, because I've had to obey it in 600 meetings of county commissioners court. But this is filed as an election contest, so it needs to be viewed under that. They wanted, the plaintiffs in the case wanted to enforce the Open Meetings Act, and the way to do it is through the election contest. So,
But you don't have to do that beforehand.
well, if the election was passed and no election contest was filed, then it would, I think it would moot the Open Meetings case. There wouldn't be, what relief are you going to get?
Right.
The Open Meetings case was filed to stop the election if possible, but we've got case law, despite the victory I had that learned counsel referred to against the city of Austin. In that same year, they were proposing charter amendments, and they just put an item on the agenda that said, consider an election for charter amendments. Well, we went to court right away. We got an injunction against them printing ballots with those charter amendments on it. Now, they didn't appeal. And there's a lot of case law out there that I'm worried about, if they had, that says the court cannot interfere in an election. So this is the dilemma that the county's position puts us in, that if you can't challenge having the election, if the court can't interfere in holding an election, even for a TOMA violation, and then you've got to wait till an election contest is filed. The court can't invalidate the election until the election contest is filed, which has to be after the election. Well, then there's absolutely no way to enforce a TOMA violation when they invalidly call it an election. And
I mean,
so,
isn't that the legislative box, though, that, pre-election, you've got TOMA, and you got an injunction if a court will grant it, and then if you don't get that in time, then you're left with an election contest where under C, TOMA comes in, it slides into the election contest statute, but you still got the same causation standard. Isn't that where we're at statutorily?
It's a good question, Justice Field, but if what we have is an unlawfully called election, that the election shouldn't even happen, and if that's the basis for the election contest, because should have obeyed the Open Meetings Act, and they didn't, so they didn't validly call the election, then it just makes no sense to say, well, we won't invalidate the election if the votes were counted correctly. But that's
So,
their
but-
position. They're saying that if the votes were
I
counted
understand that
correctly.
problem, but, you know, it says we're supposed to look at the true outcome. You're not saying there were illegal votes. You're not saying that anybody involved in the election prevented eligible voters from voting, failed to count legal votes. So is this, you're pulling this all under engaged in other fraud or illegal conduct or made a mistake?
Illegal conduct, violating the Open Meetings Act, mistake, violating the Open Meetings Act. But what is the true result in an election that shouldn't have been held in the first place? How do we say we're going to, are we putting ourselves, if we side with the county, are we putting ourselves in a position where there is no way, no remedy available at all when an election is invalidly called? It shouldn't
Well, I don't know
happen.
that there's no remedy, because it's one thing to say you didn't call the meeting valid, but it's another thing, if the problem is, as in this case, well, you didn't tell us it was roads and you didn't tell us how much the taxes were gonna be. If they put all that in the ballot, how has anybody been harmed?
Well, because the folks didn't get notice in time. That's the thing about the Open Meetings Act, is that people are entitled to know in advance of a meeting, well before the election, even before the election is called. They're entitled to advance notice that
But
that is what
we
is
don't have a
being.
ground here that, you know, that Open Meetings Act, it doesn't depend on the outcome of the votes at a city council meeting. You know, well, what would all of these people have known if they'd have known all that from the Open Meeting Act's case? So thousands would have shown up and they would have called off the election.
The public, all of them, not just the ones that showed up.
Right.
All the public is entitled to advance notice.
Right.
Of the fact that they're considering calling an election for these roads, and the opportunity then to appear face-to-face with their elected officials and try to persuade them in that meeting not to call the election.
All important rights. And on your 3-minute thing, as the other side points out, that's all you get at the legislature. You get a little more than that here, but not a lot more. and you know, that's the way we have to do it in a state with 33 million people.
But if they give proper notice, and they've been given the opportunity to try to for people to know that that's what's going on, and that's the key. What was the real subject? What was the real subject of that agenda item? It wasn't just to call a bond election. It was to call a road bond election, and that is of special interest, and you can tell from the record. It's of special interest to members of the public. And all that they had to do was just be at least a little more specific. That's what our case law teaches us.
Along those lines, I'm just curious on the notice, to go back to what I was asking Mr. Heath. Do we have a reason in the statute that the notice posted in the courthouse and the online notice aren't both considered for TOMA purposes?
The notice is the same. The notice.
Oh, it's the link.
The notice. It
Okay.
didn't say anything about agenda backup. We take exception to their argument that the notice includes all the agenda backup.
Gotcha.
But even if that was the case, then they could have just said, well, we're going to call an election. We're not even going to call it a bond election. You want to find out what kind of election, go read the backup. It's the same thing that happened in Cox, where they were talking about, well, you got personnel action. Okay, well, we took personnel action. So that's what we actually did. But wait a minute, if it's about the school superintendent, that's different. The public has a right to more specific notice. And that's exactly what this case is on the notice
So you're saying the
side.
electronic notice and the courthouse notice were the same, just the electronic notice had links and backup and,
The online notice
Gotcha.
had a link to the backup. again, on the adequacy of the notice, compare what they said on the agenda to what the election order actually said. It cleared up that this was for roads, and it was for a specific amount of money. The other analogy I want to make here is one that came up in Dacus v. Parker on the adequacy of ballot language. In Dacus, the Supreme Court said, look, you can't put out ballot language that is misleading, that either affirmatively misrepresents the characteristics and purpose of the proposition, or omit material that lets people know what the purpose is. If you could take that kind of criteria and say, did that notice on the agenda tell people what the purpose was of the election? And then when they went to the ballot language was very clear. I could not come up with a legal complaint against the ballot language. It specifically said how much money was being issued and that it was for roads.
The other side, Mr. Heath, argues that in fact there are two different standards for what the Open Meetings Act notice has to say and what the ballot language has to say, which has a kind of appeal to it, since the ballot language is what everybody votes on. Open Meetings Act is what people that are in the business of open meeting stuff go through with a fine-tooth comb.
They're both related to democracy.
I know. Is there any case
Both.
that says the standard is the same for the two? He says they're not.
I say by analogy that the standards are actually pretty similar. You can't omit a material part of what the action is that the governmental body is considering. You've got to express in that meeting notice, in the notice itself, what your action you're about to consider, at least that topic. And so you can't materially omit something from your agenda notice and then take action on it. That was my Lake Austin Collective case, where they were actually, the city council was actually granting environmental waivers, but the agenda notice said they were discussing a settlement of a case and doing so-and-so. And then when you went to the caption of the ordinance, it had all that stuff about settlement and waiver of and specifically named in the caption of the ordinance. And I always said there, and now it's similar here, why don't you just put the caption of the ordinance as your meeting notice, or something after my experience, it's not that hard to comply with the Open Meetings Act. It's just not. I think it's hyperbole to say that if you affirm the court's decision in this case, that it's going to jeopardize bond issues all over the state of Texas. First of all, the 30-day election contest deadline is long gone on those. But more importantly, if what TASB and the county are
I
suggesting.
think their argument was on the bonds. The thing that's going to have a long-term effect is if you declare the bonds invalid, that can have lots of trickle-down effects on ratings for other issuers in the state.
If that was feasible to do, at this point, those elections have already passed and the bonds are valid and being issued.
Okay, and by the way, that reminds me, what happened with the Attorney General's objection that this included roads outside East County?
They waived that on appeal.
Okay.
And so I think that if in fact what's going on is that schools have gotten in a habit, or counties or anyone, gotten in a habit of being vague about what the purpose is, they need to quit doing that. That's the solution. I disagree that there's going to be a retroactive effect for affirming this case, because somebody else would have had to file an election contest on those that have already gone to the voters and been approved. And so it's just not that difficult to, it matters to the public too if you put an agenda item up that says, we're going to build a new school, or we're going to have some school bonds, we're going to build school buildings. Then if you actually say, well, we're going to have a bond election, but what we're really doing is building a big new swimming pool. That's the reason why the Open Meetings Act requires more specific notice when something is of special interest to the public.
Mr. Elshire, in their reply, they made a big point of that if the notice is too specific, you actually undermine the Open Meetings Act because a lot of the specificity has to be decided before the open meeting. And of course, that was in their reply, and you haven't had a chance to reply. How do you reconcile that? Because it was an interesting point.
I don't disagree with that at all, and that you can get to the point where you've got so many words on the agenda item that you get lost, but that hadn't been our position.
Right.
We've shown an example of how few additional words might have been added to that agenda, and if nothing else, just say it's road bonds. If nothing else, and I agree, you don't have to put in the agenda all the consequences that might occur. That's not the point. The point is to make sure the public's being given an honest description of what those elected officials are considering, and therefore, under the act, the opportunity to come to them face to face and try to persuade them, don't do this. Either don't call the election or don't put that road project on.
Could I ask another question, just, so this was on my list of things. In the conclusion and prayer in the appellant's brief, they ask if we rule for them, would we also issue this laundry list of judicial declarations?
I'm sorry, I don't understand, Your Honor.
Okay, in the conclusion and prayer section,
Of our brief or theirs?
their brief,
Oh, okay.
it says specifically, as set forth in the county's live chapter 1205 petition, the county requests that the court enter all of these judicial declarations. Is that something?
No, if I understand your question,
Most of those are required
I
by
don't, no, I think that,
the Expedited Declaratory Judgment Act, right?
Right,
no, this is not a declaratory judgment act case.
right.
You got me confused, because I thought there were two cases, one election contest, they were combined, and then they came up to us, and where'd the other one go?
Okay. Actually, there's a TOMA basis for the election contest, and that was filed in Hayes County
Right.
as its own suit. When they filed a bond validation case, the county chose to file it in Travis County, and our election contest case was consolidated.
Right,
And
so they're not both.
oh,
in front of
I'm
us.
sorry, Your Honor, you're exactly right. There is under the bond validation, that's a declaratory action.
And there's a long list of things you gotta declare.
That
under the EDJ.
to validate the bonds.
Right.
Yes,
Yeah.
yes, and Justice Ferris, that would be necessary for some court.
Or some court, but not us here today, right?
Well, I don't know if you remand or what, but those findings would be necessary to validate the bonds.
Right,
Right, to validate the
okay, I'm
bonds.
just trying to figure out where this goes and why this is.
Yeah, well,
Okay.
Your Honor, I'm hoping you won't have to go there.
Let me ask you, I'm looking at Government Code Chapter 551, and I see lots in here about, if you don't comply with it, you can be guilty of criminal act and misdemeanor violations, all that stuff. What they don't say is that anything you approved is void. They say it's voidable,
Right,
but then that kicks in, if what you're wanting to void is the election, I understand your argument is, well, we want to just void calling the election, but this point, that's water under the bridge. There's been an election, and the election code says you got to show outcome would have been different. So wouldn't they have said that in Chapter 551 if that's what they meant?
There are civil violations and criminal violations, and we're just on the civil side. So the remedy there is to reverse the action they took in violation
But
of the
your
act.
point is, this is outrageous that they don't say, this is a road bond for X billion dollars. And the fact of the matter is, if that's what they did, those people can get in trouble.
Well,
I mean, I agree
not
with you.
criminal.
That's
A-
terrible.
A
I don't-
violation of the meeting notice provision is not a criminal violation. It's civilly enforced. But to speak to the avoidable void issue, and I'm almost out of time, but what has to happen for this to make any sense, their argument that because we couldn't have a judge declare the election contest until after the election, but if it's after the election, the judge can't void the calling of the election in the first place. That just makes no sense. So we've got to look at the judge's order voiding the order calling the election to have retroactive effect that says, okay, now you didn't validly call the election, therefore the election is also void. And without the election, you cannot issue those bonds.
Anything else? Any other questions?
Thank you, Your Honor.
Mr. Heath?
I'm sorry to take a little bit of your rebuttal time, but if we did rule for you, why would we be the court that would be entering all these declarations? As
Well,
to,
You've already ruled on that, as I understand, that there was a motion to transfer it, which was denied. But it's because the Attorney General is a party,
okay,
and he is certainly interested in the consolidated case, which is the bond validation suit.
but this wouldn't be a remand.
Pardon?
But this wouldn't be a remand for the.
I don't think it would be remand. I think if you say the election was valid, then I think there's no reason that the bonds cannot be validated.
And you can let us know if you see something different, but I mean, I think the Attorney General has to be a party
Oh,
of those
yes,
declarations for it to be binding bonds.
Right.
And
But,
I don't
you
know if
know,
he'll volunteer to reappear if we remand.
I beg your pardon?
I don't know if he'll volunteer to reappear if we remand.
I don't know.
Yeah.
One thing, I think it's important to recognize what the purpose of the enforcement provisions in the Open Meetings Act is. We talked a lot about that. And it's not really to necessarily reverse what the government did. It's to get them to comply. And that's the reason that things are voidable, not void. If it's voidable, it is presumed to be valid, and that's what you want a governmental action to be, but the governmental action is presumed to be valid unless and until it is invalidated by the court. Now, in this case, by the time the election was held, there had been no determination that the election order was invalid. It was presumed to be valid, and the election was conducted. The election order is gone. It served its purpose. And what they're trying to do is say, well, we're going to invalidate the election. Well, if something's voidable, you need to bring a direct attack against it, not a collateral attack by going and invalidating something else or challenging something else. And that also occurs in the Friends of Canyon Lake case. If you read in that, and it's not really the part that we discussed so much in the brief, but the question there was, assuming that that notice was invalid and that the action taken at the meeting was invalid, and the meeting action was to apply for an amendment to the permit issued by Tenrick to draw water from Canyon Lake. You need to challenge that amendment, the authorization for the amendment, not go and challenge what Tenrick did later on after they considered and granted it. By that time, it's too late, and it's too late when you have the election. And of course, that's what Scarborough said in multiple cases following that, and I think as a policy matter, it makes particular sense because once the people have voted, that's the ultimate authority, and we don't go back and in the case of Scarborough say, well, you didn't meet, it wasn't a question of posting notice, but you didn't meet the predicate for even calling the election. And the Supreme Court said it doesn't really matter. Now, the question of, is there no way to challenge this? It may be hard to challenge it. I admitted that. But we know the council thought that there was a way and pursued that. Now he's saying, well, if we had gone to the Court of Appeals, we probably would have lost. But apparently he didn't think that when he filed the lawsuit, and he was successful. I think, you know, that may be something that people would raise on appeal, but there is a way to bring challenges to an election. It's narrow, it's difficult, and it's set out by the Supreme Court in Bloom versus Lanier. Bloom versus Lanier was decided, it's in 999 Southwest 2nd, is my recollection. And again, Chief Justice Phillips was the author of it. But if you can facilitate the election, not delay it, you can bring injunctive action and get it granted. Thank you.
Thank you, gentlemen. Case will be submitted. Marshal will adjourn the court.
All rise. 15th Court of Appeals now stands adjourned.
Yeah. Uh-huh. Well, so was I. A long time.